This is Barry Zalma on insurance. I'm an attorney who's retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to continue talking about domicile and residence, and specifically the requirement in a homeowner's policy for the insured to reside at the residence premises for coverage to apply. The policy language in a homeowner's policy unambiguously requires that the property at issue, that is, the property that is the subject of the insurance, requires that the insured, the person who purchased insurance against the risk of loss of a particular residence, must actually live there. It does not require that the property be the insured's domicile, but it does require that the property that is the subject of the insurance is the insured's residence. The insured location was defined in relevant part to mean the residence premises, and the residence premises was designed by the homeowner's policy to mean the dwelling where the insured or insureds reside, and which is shown as the residence premises in the declarations page of the insurance policy. Faced with such clear and unambiguous language, a court is required to enforce the exact language of the policy that unambiguously required the insured to reside at the insured premises at the time of a loss. If the insured resided in a different location, there could be no coverage. A policy's definition of residence premises that specifically requires that the property listed as the insured property be the property where the insured resides. When a plaintiff's application for homeowners insurance indicated that the home would be occupied by the owners, that is, the plaintiffs, and not a tenant, they were required to live there for the coverages promised to apply. Furthermore, as relevant to the circumstances at issue in a trial, occupy means to reside in as an owner or tenant, because there is no irreconcilable conflict between the provisions. The named insured plaintiffs could not establish the existence of an ambiguity in the insurance contract. It is clear and unambiguous when it requires the insured to actually live in the residence premises that is the subject of the insurance. Because of the use of and not or in the policy's definition of residence premises requires more than residence, it also requires the persons insured to live there. That residence requirement is clear and explicit, and the plain, ordinary, and generally prevailing meaning of the word reside requires more than purchasing a home or intending to move into it. The Fifth Circuit Court of Appeal concluded that once the insureds repeatedly admitted that they never resided at the property, the home did not satisfy the policy's residence requirement and was not a covered residence premises. This was Giovera Specialty versus Joaquin, a Fifth Circuit decision in 2020. The insurance contract, the homeowner's policy, covers the dwelling on the residence premises, and the contract defines such as a dwelling, quote, where you reside, close quote. Only the residential dwelling is covered by the policy. The dwelling must also only be a place used by the person insured as a residence. Had the insurer not wished to limit coverage to a property resided in by the insured, it could have provided coverage for the insured's domicile. Homeowners insurers have not used the word domicile, but instead insisted on residence to limit the exposure to loss. Therefore, if the insured takes up residence elsewhere, like being assigned to an office in London, England for 6 months, the insured did not reside in the dwelling in New Hampshire, the risk of loss of which was insured by the homeowner's policy. Similarly, if the insured became ill and was confined to a hospital or a board and care facility for 6 months of the time the residence changed, although the insured's domicile did not. Ohio courts, like courts in every state, give insurance contract terms their plain and ordinary meaning, unless another meaning is clearly apparent from the contents of the policy. A plaintiff's argument that residence is ambiguous because the contract includes specific coverage exclusions for vandalism, theft, and frozen pipes if the property is unoccupied was unavailing because although the term residence may be ambiguous in other contexts, there is no ambiguity where, as in the homeowner's policy, the specific language clearly defines the term. A court must conclude that the insurance contract language makes clear that recovery of indemnity was conditioned upon the plaintiff actually residing at the location at the time of the loss. When the language of the homeowner's policy, read as a whole, and with an eye to the risks insured, was clear to the Second Circuit Court of Appeal and many other courts, the language cannot reasonably be read to provide coverage to the noted residence premises if they did not reside at that location. Consider MIC General Insurance versus Allen, a Second Circuit Court of Appeal decision from 2017. In Michigan, a case where the insured Patrick bought a house in Detroit, Michigan for the munificent sum of $3,600. At that time, the house was uninhabitable because it was missing almost everything but walls and a roof. It had no running water, no working toilets, no furnace, no kitchen cabinets. The water lines had frozen. Scrappers had stripped the other pipes. Regardless, Patrick bought a homeowner's policy and made a claim a month later. The Sixth Circuit concluded that Patrick argued that she simultaneously resided in the house with her son because she lived there, and in the house she had purchased because she intended to live there in the future. The jury rejected her argument and returned a verdict in State Farm's favor. The Sixth Circuit affirmed the decision of the jury in Patrick v. State Farm, a 2018 decision of the Sixth Circuit Court of Appeal. Obviously, the policy was purchased fraudulently. No insurer with any sense would insure against the risk of loss of a dwelling that was only 4 walls and a roof and could not be lived in, with a homeowner's policy that required the insured to actually live in the house. Ms. Patrick was lucky she was not charged with fraud for bringing suit against State Farm to collect on the fraudulently purchased policy. In Hennesser versus Frankenmuth, a 1995 decision of the Michigan Supreme Court, that court held that an insured who did not reside at the insured premises was unable to make a claim for losses under a homeowner's policy, which clearly required the insured to reside in the home. The requirement that the insured reside in the premises applies to both damage to the property and to liability coverages. The New York Appellate Division concluded that the motion court correctly found that plaintiff established prima facie that it had no obligation to defend or indemnify defendant Hossein in the underlying personal injury action by showing, pursuant to an exclusion in his homeowner's policy, that Hossein did not reside at the premises when the accident happened. The insurer proved its case with the affidavit by the plaintiff's insurance investigator stating Hossein admitted that he had not resided at the premises since November 2008, nearly a year and a half before the accident occurred. This was Tower Insurance Company of New York versus Hossein, a 2015 decision of the New York Appellate Courts. The standard for determining residence for purposes of insurance coverage requires something more than temporary or physical presence at the insured premises. A person must show some degree of permanence and an intention to remain. Consider Neary versus Tower Insurance, a 2012 decision of the New York Appellate Courts. Mere intention to reside at a certain premises is not sufficient, since there was no dispute that the named insureds did not reside at the insured premises, nor did they even intend to reside there. The misrepresentation on the application for insurance was, in New York, sufficient to rescind the policy in a case called D'Agostino versus Allstate in 2015. The United States District Court in North Dakota considered the issue and concluded that to require the insurance company to provide coverage for property not used as the insured's residence premises would constitute an extension of liability where none previously existed. According to the plain language of the homeowner's policy, the insured must reside at the insured premises for there to be coverage. Because in Center versus Blake, a 2005 decision of the District of North Dakota, Blake did not reside at the insured location at the time of the accident, and therefore coverage was excluded, and the plaintiff insurance company was entitled to summary judgment, relieving it of its duties to defend and indemnify Blake and to pay for an injured person's medical expenses. It is essential when dealing with insurance claims and the interpretation of insurance policies to understand the meaning of domicile and residence and how each term is different. A person insured may have multiple residences, while an insured can have only one domicile. When a policy requires an insured to reside in the dwelling that is the subject of the insurance, it is imperative that the insured actually live in the residence. Moving to a second home, spending a summer in a winter home, spending a winter at home in Florida, can deprive the insured of coverage for losses at the dwelling that may be the domicile but is not the insured's residence at the time of a loss. It is incumbent on people with more than one residence, whether intentional or because of health reasons, to explain that fact to the insurer, to have it endorsed to cover a premises that is perhaps unoccupied, vacant, or rented to tenants, and protect the person who has a different residence. This video was adapted from my research and my book, The Homeowners Insurance Policy. It is also the second part of the video from the day before, dealing with the definitions and understanding of the meaning of the terms domicile and residence when used by an insurer. If you found this video to be useful to you and your colleagues, please forward it to your colleagues. It's free. And please also subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn about future videos and blog postings. All of the links are at the end of the location where this and description of this video. Thank you for your attention.